policies, regulations, training, or delivery of state services and/or state law can be improved at both the agency and systemic levels. Our focus always is on the children of the Commonwealth, their needs, their rights, their well-being. As you will hear today,
This way. Take a step this way. Towards me. Good.
as you will hear today, our central and most important finding in this investigation is that unfortunately, and with serious consequences, Harmony Montgomery's individual being and safety were not prioritized or considered on an equal footing with the assertion of a parent's rights to care for her in any aspect of the decision making by any state entity. This report describes the ripple effects of miscalculations of safety and risk and the unequal weight that was placed at multiple decision points across our system on Harmony's parents' rights versus her own well-being. To be clear, I am not here today to ascribe blame to any individuals. Child Protective Service work is the hardest job in government. The OCA's reviews have the benefit of hindsight. Details that appear clear now may not have been as clear at the time the decisions were made and actions were taken. The OCA issues our findings and recommendations today with the goal of advancing systemic reform that puts the needs, rights, and well-being of children first. Before I begin to address our findings and recommendations, I would like to start by telling you what we know about Harmony Montgomery. At birth, medical experts believed that Harmony would never see and that she would be severely disabled. However, Harmony defied expectations. Although blind in one eye, she grew stronger with each passing week. As she grew into a toddler, it was clear that although she had visual disabilities, she had developed superior coping mechanisms as well as a knack for overcoming challenges. Harmony was independent as a toddler and very young child. She liked books, playing with dolls, and playing with other children. She is described as both charming and very active. Harmony had very well developed language skill and was known to be very empathetic. Harmony loved all types of foods, including onions. As a young child, she had the opportunity to play in a vegetable garden and would pick the cherry tomatoes and cucumbers. Our knowledge of Harmony ends at age 4.5 when she moved to New Hampshire to live with her father. From that age on, we do not know what happened to her, nor do we know where she is today. We do not lose hope, however, that she will be found. I want to provide some background on the family. This case involved two states, both Massachusetts, where Harmony was born and taken into state care at 2 months old, and New Hampshire, where her father lived at the time that a Massachusetts court granted him permanent custody. For the purpose of this investigation, the OCA is only concerned with the actions that occurred in Massachusetts before custody was granted to her father. These events took place over a 5-year span, beginning in 2014 and ending in February of 2019. Harmony was born in 2014. Harmony was solely in the care of her mother, Crystal Sorey, at the time, as her father, Adam Montgomery, was incarcerated. Her parents never married. At 2 months old, Harmony was removed from the care and custody of Miss Sorey. Harmony spent the majority of the next 4 years of her life in foster care, although DCF attempted to reunify Harmony and her mother twice during this period, once in 2015 and again in 2017. Over the same period, Mr. Montgomery had sporadic contact with Harmony. There were periods when he requested visits, interspersed with long periods of time when he had no contact with his daughter. The OCA estimates that Harmony spent a total of approximately 40 hours over the course of 20 supervised visits with her father from birth to age 4.5. In February of 2019, a juvenile court judge awarded custody of Harmony to Mr. Montgomery. At the same time, the judge also ruled that the interstate compact on the placement of children did not apply in this case, which meant that there was no requirement to conduct a home study review of Mr. Montgomery and his wife, Kayla Montgomery, in New Hampshire. The DCF attorney opposed placing Harmony in Mr. Montgomery's care on the grounds that he was unfit and that Harmony should remain in DCF custody at least until the ICPC home study was completed. Mr. Montgomery's attorney, Ms. Sori's attorney, and Harmony's attorney were all in favor of Mr. Montgomery receiving custody of Harmony and did not object to Harmony being returned to Mr. Montgomery without an ICPC home study. Approximately 1 week later, Harmony moved from her foster home placement into the home of Mr. and Mrs. Montgomery in New Hampshire. This ended DCF's involvement as the DCF case automatically closed when custody was awarded to Mr. Montgomery. It would be another 2 years and 10 months before New Hampshire discovered that Harmony had not been seen since November of 2019, 8 months after she moved to New Hampshire from Massachusetts. This case is complicated by the many legal issues involved in a Child Protective Service case. The modern Child Protective Services legal framework began in the early 1970s, when every state adopted a mandatory reporting system for reporting child maltreatment. The goal of the Child Protective Services system is to preserve families while protecting children. In most situations, the best place for children to be raised is with their families. However, there are sadly times when that puts the child at significant risk. As a result, child protection always requires a careful assessment of risk and the need to balance the harm of removal with the potential harm that can come from failing to remove a child from an unsafe situation. We must also recognize that children of color and poor children disproportionately come to the attention of the Child Protective Service system. And these ongoing disparities require our focus and consideration when considering systemic reforms. To remove a child from the parent's custody raises serious constitutional issues about the exercise of state power. Under both the Massachusetts and federal constitutions, the state can only intervene and assume custody when the child's safety is at immediate and substantial risk. The majority of cases that come to the Child Protective Services system fit in the broad category of neglect. Neglect can encompass a wide variety of issues, but it is worth underscoring that the legal standard for removal is substantial risk. In the many cases the OCA reviews where neglect has been alleged, the underlying issue is that a parent's substance use has led to a situation in which a child was placed at a substantial risk of harm. For example, the parent passes out, leaving a newborn baby unattended at the risk of dehydration, or a toddler at risk of any of the many things a toddler might do inadvertently to harm themselves while being left unattended for a long period of time. It is important to assume that cases of neglect are therefore not benign. Children can and have died of neglect. In addition to proving that a child is at immediate and substantial risk, the state must prove that a parent is currently unfit. The word current is important to remember in this case. Our law assumes the possibility of a parent or their situation changing for the better. The state also has the burden of proving that there are no reasonable efforts that can be provided to the family in the form of services and supports that could prevent removal. Decisions in care and protection proceedings, which is what these cases are called, are filed on behalf of children. Although the state must prove the current unfitness of the parent, Massachusetts statutes require judges in making these decisions to also consider what is in the best interest of the child. This legal framework provides context for the decisions that were made in the court hearing in February of 2019 that resulted in custody of Harmony being awarded to Mr. Montgomery. Our key findings. As I stated above, the central finding of this investigation is that Harmony's individual needs, well-being, and safety were not prioritized or considered on an equal footing with the assertion of her parents' right to care for her in any aspect of the decision making by any state entity. This manifested across a variety of decisions that were made by various actors over the course of Harmony's life. I'm going to first discuss DCF's case management of this case prior to the February 2019 custody hearing. The OCA found that DCF's clinical assessment and case manage focused primarily on Harmony's mother, Crystal Soaring. Harmony's father, Adam Montgomery, was in prison when DCF's involvement with Harmony began. Although he was non-responsive for long periods of time, during the times when he appeared to be in communication with the DCF case management team, they were not able to engage him, except to facilitate his supervised visits with Harmony. No assessment was ever completed on Mr. Montgomery, and he was not held accountable for starting and completing the tasks on his action plan. The DCF case management team, therefore, had little understanding of his family or personal history from which to develop an action plan and from which they could assess his capacity to parent Harmony. We also found that Harmony's individual medical and special needs were not central to the decision-making in her two reunifications with Ms. Soaring. The lack of focus on her needs and the insufficient balancing of her well-being with Ms. Soaring and Mr. Montgomery's rights resulted in significant placement instability for Harmony, as she was moved back and forth between Ms. Soaring's home and the home of her foster parents multiple times. The result was significant reported trauma and harm to Harmony's well-being in the early years of her life. Moving on to the legal system, I will note that the OCA's investigation was limited in some respects, as much of the information and documentation was shielded by attorney-client privilege. However, the OCA did review tapes of the court hearings and all available court filings and documents. Based on that review, we have determined that Harmony was also not prioritized in the legal case regarding her own care and protection. Neither the judge nor any of the attorneys in the case put Harmony's needs, safety, or well-being at the center of the discussion of custody. There was also no discussion of how Harmony could safely transition to Mr. Montgomery's care once the custody decision had been made. The OCA found that the DCF attorney did not present a strong legal case for opposing placing Harmony in Mr. Montgomery's care. As stated above, there was no assessment of Mr. Montgomery, and this significantly impacted the strength of DCF's legal case opposing placing Harmony in Mr. Montgomery's care. Similarly, Harmony's attorney did not present information on what might be in her best interest. no evidence on her needs, no statement about Harmony's specific desired legal outcome, no argument about what she needed to be safe and to thrive. Harmony's attorney also did not state any opposition to proceeding with custody without an ICPC, knowing full well that DCF was never able to conduct a proper assessment of the Montgomery family. The OCA recognizes that Harmony's attorney was not required to do any of this under the current Committee for Public Counsel Services standards of representation. But we believe that Harmony's interests and safety would have been better represented if they had, and I will discuss this further in a few moments. The OCA found that the court awarded cross-border custody without compliance with the requirements of the ICPC, relying on New Hampshire case law over Massachusetts case law. The OCA believes that the procedures outlined in the ICPC, if they had been applied in Harmony's case, would have helped to address the safety and risk concerns for Harmony when she was transferred to Mr. Montgomery's care. This would have included confirming the Montgomery's family living situation in New Hampshire and Mrs. Montgomery's current sobriety, continued oversight of placement by the New Hampshire DCYF, and ensuring that Harmony was connected to services and resources in New Hampshire, including schools. Recommendations. Based on the findings I have laid out in this report, the OCA makes a series of recommendations primarily directed at DCF, the Juvenile Court, and the Committee for Public Counsel Services. I first want to note that there are similarities between the OCA's investigation into the death of David Almond, which we released in March of 2021, and in Harmony's case. The decision to place Harmony with her father and to return David to his father both took place in 2019. Many of the OCA's 26 recommendations from the Almond case could be applied to Harmony's case. The OCA recognizes, however, that since the 2021 Almond report, there have been extensive improvements in both DCF and the juvenile court policy and practice. This information is highlighted in a report that the OCA released several weeks ago. For this reason, we focus on a series of new recommendations based on the facts of this case. Some examples of the recommendations include that DCF should develop a comprehensive plan to ensure that both parents are adequately assessed and receive the support and access to services so that their children can achieve permanency. DCF must make sure that fathers are provided the same level of attention as mothers. We also recommend that DCF work to improve the quality of its legal advocacy with a focus on improving training, ongoing litigation support, and supervision of their attorneys. Moving on to the broader legal system, we recommend that the Committee for Public Counsel Services, which trained and certified the attorneys for mother, father, and Harmony in this case, conduct a comprehensive review of the suitability of the standards of advocacy provided for children in care and protection cases, and the adequacy of CPCS's supervision over the quality of that representation. As I discussed previously, we believe that the current CPCS standards of representation should be revised to ensure that the best interests of children are presented to the court in addition to the direct advocacy to support the child's wishes. We recommend that DCF and the juvenile court work to identify barriers to permanency and reduce the amount of time it takes for there to be a final adjudication of adoption, guardianship, or return to parent for a child. Delays in permanency can be extraordinarily damaging, particularly to young children. We recommend the juvenile court and DCF work in various ways to improve cross border communication and safety practices, including a recommendation on training judges and attorneys on the ICPC, as well as recommendations that Massachusetts continue working with our neighbors in New England to close gaps in information sharing across borders. Finally, we recommend the establishment of a working group to hold in-depth policy discussions on how considerations regarding a child's welfare and best interests are currently presented in care and protection cases, and what changes may be needed to ensure that a parent's rights are appropriately balanced with a child's needs. We recognize that this is a complex issue that requires multiple stakeholders at the table, but we urgently believe our legal system must do a better job of ensuring that the best interests of children is properly considered in custody cases and not outweighed by the constitutional rights of that child's parents. This is a vital conversation that needs to be had, and we hope our colleagues in the executive, legislative, and judicial branches will come to the table for that discussion. When children are not at the center of every aspect of the Child Protective Service system, then the system cannot truly protect them. We do not know Harmony Montgomery's ultimate fate, and unfortunately, we may never. But we do know that this beautiful young child experienced many tragedies in her short life, and that by not putting her and her needs first, our system ultimately failed her. We owe it to her to make the changes necessary to allow our system to do better in the future.